My name is TUSHAR and today I'll be covering a case study analysis of a very important topic of a field, which is legal ethics and court crafts. And the case name is R. Muthukrishnan versus the Registrar General of the High Court or Adjudicature of Madras. The citation is writ petition number 612 of 2016/AIR 2019, Supreme Court 849. The date of the judgment is 28th of January 2019 and the honorable bench was Honorable Justice Arun Mishra. So first I'll tell you the facts, the case details. I've already told you the facts, the issue of the case, the rule 14A which has been applied in the case, the key aspects and what was held in the case. So first we'll go with the facts of the case. The petitioner, an advocate, has filed the petition under Article 32 of the Constitution of India, questioning the virus of amended rules of 14A, 14B, 14C, 14D of the rules of High Court of Madras 1970, which was made by High Court of Madras under Section 34(1) of the Advocates Act 1961. The High Court has inserted Rule 14A in the rules of Madras High Court of Madras 1970, empowering the High Court to debar an advocate from practicing. So the High Court has been empowered to take an action under Rule 14B where any misconduct referred to under Article 14A is committed by an advocate before the High Court. Then the High Court can debar him from appearing before the High Court and subordinate courts. So under 14B, the principal judge has been empowered to initiate action against that advocate concerned and debar him from appearing before any court or with such district courts. So in the case of misconduct which is committed before any subordinate court, the concerned court shall submit a report to the principal district judge, and in that case the principal judge shall have the power to take an appropriate action. The procedure to be followed has been provided in the newly inserted Rule 14C. And pending inquiry, there is power conferred by the Rule 14D to pass an interim order prohibiting that the advocate concerned from appearing before the Honorable High Court or subordinate courts. So, in the issue of this case was that the petitioner has questioned the virus of amended rules of 14A to D on the grounds of being violation of Article 14 and 19(1)G of the Constitution of India, as also Section 30, 34, 1, 35 and 49(1)C of the Advocates Act 1961, as the power to debar for such misconduct has been conferred upon the Bar Council of Tamil Nadu and Puducherry, and the High Court could not have framed such rules with ken of Section 34(1) of Advocates Act. And the key aspect was whether the ambit of Section 34(1) is in tune with the directions issued by the court in R.K. Anand versus Registrar, Delhi High Court. R.K. Anand decision is departure from the precedent established. Whether debarment by the way of disciplinary measure is outside the purview of Section 34(1) of the Advocates Act, and the rules are ultra vires and impossible to be framed with scope of Section 34(1) of the Advocates Act, as they take away the independence of the bar and run contrary to the Constitution Bench decision of this court in Supreme Court Bar Association versus Union of India. So whether disciplinary power was vested in the Bar Council can taken away by the court. So after a review of international scenario in this regard, the ethical standard of legal profession and legal education has been assigned to the Bar Council, and it has to maintain the dignity of legal profession and independence of the bar. The Bar Association must be self-governing, is globally recognized, and the provision and scheme of Advocates Act has never intended to confer the disciplinary powers upon the High Court or upon Supreme Court, except to the extent dealing with an appeal under Section 38. So, Section 34 of the Act does not confer such power to frame rule or to debar a lawyer from professional misconduct. The amendment made by providing Rule 14A is not authorized under the Advocates Act. The High Court has no power to exercise the disciplinary control. It would amount to usurpation of the power of Bar Council conferred by under the Advocates Act. However, the High Court may punish the advocate for contempt of court and then debar him from practicing. But as may be permissible in accordance with law, but without exercising contempt jurisdiction by way of disciplinary control, no punishment can be imposed by the High Court. As such, impungent rules could not have been framed with purview of Section 34, which states that there are no such rules that have been framed under Section 34 of the Act, that it has not been mentioned. And in R.K. Anand case, the decision is not a departure from other decisions, but rather affirms. In Harish Uppal Supreme Court Bar Association, in Praveen C. Shah versus K. M. Mohammad Ali case, which was referred. And it was held by the court at last that the High Court has overstretched and exceeded its power, even in the situation which was so grim, which appears to have compelled it to take such a measure, and it can take action, punish for contempt of court in case it involves misconduct done in the courts or proceedings. Circumstances may be grim, but the autonomy of the bar in the disciplinary matters cannot be taken over by the court. The misconduct as specified in Rule 14A may also be, in appropriate cases, tantamount or to contempt of court and can be taken care by the High Court in its contempt jurisdiction. So resultantly, we have no hesitation to strike down impungent Rules 14A to D as framed in May 2016 by High Court of Madras, as they are ultra vires to Section 34 of the Advocates Act and are hereby quashed. The writ petition was allowed without any cost. That was mentioned in this case. Thank you.